Hello, welcome back to Legal Brain. Now I'm going to take a class about abuse of dominant position. So in today's class, I'm going to discuss about what is abuse, what is dominant position based on Competition Act of 2002. So Section 4 of Competition Act speaks about dominant position. So in simple terms, by virtue of Section 4, dominant position implies the quality of an endeavor in the significant market in India, which empowers the enterprise to work autonomously of serious powers winning in the market and to influence the customers of the market in support for it. So that is the dominant position where an endeavor or an enterprise is holding a superior position in the market with a lot of powers. So the factors to determine whether a particular enterprise is having a dominant position, that's what we're going to check now. So these are the factors. First one is market share will be very high, and the size and assets of the undertaking would be really high. Then the size and significance of the contenders of the competitions will be high. Then the financial intensity of the undertaking, a vertical combination or integration, reliance on customers on the undertaking, then a degree of selection and exit, entry and exit barriers, countervailing purchasing power, then a source of dominant position, then social expenses and commitments of big business. Then all these are the different factors that is determining whether your enterprise is having a dominant position in the market. So if at all, if you satisfy any of these points, it means that you have a dominant position in the market, and the Competition Commission of India is approved to, additionally, other than these points, approved to consider whatever other factors that is causing a domination in the market. So next is, what is market? What is a relevant market? So this can be like a short answer type question, like what is a relevant market? So relevant market in which the accused party has a dominant position. The reason served by depicting a relevant markers is to characterize the degree inside which the situation of an endeavor is to be tried for strength and misuse of it. And also the technical term product is very important, and geography is also very important when it comes to a relevant market. And relevant product market is another term, a technical term which is again important, can be a short type answer. So a market comprises of all those products or services that are interchangeable or are substituted by the consumer. That means it's like different types of product that we can substitute each other. So if there is no product to substitute each other, there will be a scarcity. So the necessity, the need, the demand will be really high. And if there is a scarcity, obviously there can be these firms or enterprise can have a abuse of dominant position. So the relevant product markets are physical characteristics or end use of goods, price of goods or services, consumer preference, exclusion of in-house products, producers, existence of specialized producers, and so on. So these are the relevant market product. And again, I'm going to discuss two important case laws that's very relevant. First one is Atos Worldline versus Verifone India case. So in this particular case, the Competition Commission of India held that the relevant product market is to be looked at from both demand and supply. In both demand and supply perspective, we have to look the relevant product market based on the characteristics of the product. We should know whether some other product can substitute it or not. The next case is Sundar Singh case, which is again an important case in 2010. So Sundar Singh Burmi versus Board of Control for Cricket in India, that is BCCI, India case. So again, in this case, it was stated that regarding the relevant product market, the relevant market was settled on the thought of demand substitutability of different types of amusement or entertainment. The meaning is that if you could substitute a particular amusement with other, then that is fine. A simple example, even in the case law, it was stated that a cricket match could not be held to be, substitutable by any other game. Like we cannot substitute cricket with football. For cricket, we need cricket. So that is the meaning. So cricket match couldn't be, held to be substitutable by some other game, dependent on neither qualities nor the intention of the person watching the cricket match. So this is the meaning. Like there should be substitutability in the market. If it is not there, there can be a abuse of dominant position. Next is relevant geographical market, which is again another important area, and the factors determining whether The relevant geographical markets are regulatory trade barriers, local specialization, national procurement policies, adequate distribution facilities, transport costs, language, and so on. So a market comprising the area in which the condition of competition for supply and demand of goods and services are distinctly homogeneous. Then next is how to identify when there is an abuse of dominant position. How to know that there is an abuse of dominant position. So section 4 subclause 2 speaks about this, and there are like 5 kinds of abuse of dominant position. First one is unfair or biased trade practices. So in the market, if there is any unfair or biased trade practices, we can say that there is abuse of dominant position. So according to this, abuse of dominant position happens when an undertaking or like gathering legitimately or in an indirect way forces prejudicial conditions on the sale of goods or rendering of cost and cost in deal or acquisition. So there should not be any unfair trade practices when it comes to a relevant market structure. The second point is limiting creation or specialized or scientific improvement. That means we are limiting the creations and we are abusing the dominant position. We are, just exploiting the need in the market, and we are like raising the prices and we are selling the price. The next is a denial of access to showcase barriers to entry and development. So that means pure exit and entry barrier. We have to make sure that the firms or enterprise can enter the market and exit the market freely without any kind of abuse. Fourth point is the imposition of beneficial commitments. And fifth point is the protection of different markets. And the meaning of that is that when an enterprise utilizes its situation in a significant market to go into other market, at that point, there is an abuse of dominant position. These are the main 5 points that is considered as abuse of dominant position. Now, based on section 4, subclause 2 of the Act, which indicate that the accompanying practices by a dominant enterprise or a group of endeavors are, they are like as they misuses and in indirect way imposing out of line or oppressive conditions in the sale or purchase of the goods or services. So which can be like, it can be a direct way of abuse or which can be even indirect way of abuse. And any unjust activity or any unjust activity boosting one particular firm and giving more importance than like restricting other firms and enterprise can lead to abuse of dominant position, which even include constraining or confining the creation of products, then constraining or confining specialized or local improvement. All these are like limiting, and also denying market access, making the finish of agreements, then using its dominant position in one important market to enter into and to ensure applicable market. So these conditions are abuse of dominant position. Next is types of abuse of dominant position. Types of dominant position are of 2 types. First one is exploitative, such as excessive pricing. That means, in simple terms, the meaning is that where the prevailing body abuses its strength by forcing biased or potentially low conditions on different firms or shoppers. So they're just trying to exploit the customers. So again, there is an important case law, Pankaj Agarwal case, that is 2010 case. So in this case, whereas for a situation relating to the distribution of apartment, that's mainly known as DLF case. So in this case, the agreements drafted singularly by Delhi Land and Finance and empowered them to be a discretionary, about the design of super area and secretive about data pertinent to the buyer. So like the number of the apartment to the floor and to drop portions and relinquish booking sums, the commission held that the agreements to be exploitative against purchases. So whenever there is an agreement, it should not be exploitative in nature. Exploitative, that means, excessive pricing in nature. So commission point out that, and consequently it was one-sided and abusive. The court ruled out that. So in this particular case, DLF was, doing an, exploitation, and they are doing excessive pricing. And the second point is such as denial of market, like exclusionary. That meaning is denial of market access. So I've told you there should be free entry and exit, market exit. So exclusionary activities are those in which the dominant body utilizes strength to confine entry of the competition in the relevant market. So again, there is an important case law by CCA, that is Shri Shamshir Kataria versus Seal Honda Limited. I have already discussed this case in in other classes. So in this case, it was held that there is an abuse of dominant position. So where they're already existed agreement between the dominant entities and overseas suppliers of unique vehicle parts, and that can lead to an abuse. It was held that anti-competitive. It is anti-competitive in nature and it is abusive. And now, what can we do if there is an abuse of dominant positions? This is the first one is procedure followed by the Commission in India. So by virtue of Section 19, the Competition Commission of India is having the powers, and the Commission may ask into, any supposed negation based on Section 4, subclause 1 of the Act, and also based on Section 19, subclause 4, the Commission is having a power and gives a detailed list of elements that the Commission will consider while asking into the claim of abuse of dominant position. So you have to keep in mind Section 19, subclause 4, and you have to check whether there is abuse of dominant position. So once when the CCI gets a complaint, or once when CCI is sumo moto, started investigating, CCI will guide the DG, Director General, to cause an examination and to give a report. And after that, the Commission has forces, it has the power of civil court, and also it's a like quasi-judicial body. So under the Code of Civil Procedure, CPC, in regard to the issues, like they have the power to summon, ask for, authorizing the participation of any individual, examining him on the pledge, and so on. So like they are having the powers of a civil court. And the Director General, to complete an examination, is vested with forces of the civil court order, rather than, they have the powers. And also, next is powers of commission. What are the powers of the commission? So it starts from Section 27. So they have, direct the parties to suspend and not to appear on such type of understanding. Then the Commission can direct the endeavor or enterprise concerned to alter or change the agreement. So like making changes in the agreement, then direct the enterprise concerned to submit to such different requests as the Commission may pass and conform to the bearing, including payment of expenses. Then the Commission can ask to pass such different orders or issue such, we can give direction to the enterprises. Fifth is they can enforce such punishment, and it might consider deemed fit. So they can impose the punishment, mainly can have to be 10% of the normal turnover for the last 3 presiding financial years of endless supply. And, it is according to them, they can just give the fine. Last point is Section 28. Section 28 enables the Commission to coordinate the division of a venture or enterprise, appreciating the prevailing situation to guarantee that such an undertaking does not showcase any abuse of dominant position. So this is the main target. And next is interim order. The Commission is having a power to pass an interim order, and based on Section 33 of the Act. So during the pendency of an investigation into abuse of dominant position, the Commission may incidentally control any party from duration with the alleged offending act, and again pass an interim order. Next is appeals. We can go for an appeal. The Competition Appellate Tribunal, that is called COMPAT, C-O-M-P-A-T, Competition Appellate Tribunal, is set up under Section 53A of the Act. So to hear and discard the claims against any cause given or a choice made or order passed by the Commission, so that we can go for an appeal, or based on this particular provision, an appeal must be documented inside 60 days of receipt of the order or direction or choice of the Commission. So within 60 days, we have to go for the appeal. So this is the concept of abuse of dominant position. So we have discussed about what is abuse, what is dominant position, what is relevant market, what are the conditions that is, discussing about a dominant position, the powers of the Commission if there is dominant position, how to conduct an inquiry if there is dominant position. This is an important question. Hope it's clear for you. Thank you for listening to me.